Tonight, the federal government taking New Mexico and its largest city to court, escalating a high-stakes fight over immigration enforcement. And at the center of the legal battle, New Mexico's Immigrant Safety Act. It bars local governments from contracting with ICE, and it's set to take effect in less than 2 weeks. The Trump administration wants to block it, saying it undercuts federal immigration enforcement. But the state's pushing back, saying it's about protecting public safety. We first brought this to you as breaking news at 4. The Immigrant Safety Act isn't the only thing the DOJ wants struck down.
Leah Chavez is here with how the city is also a target of the lawsuit.
Yeah, that's right. The lawsuit also targets an Albuquerque ordinance that restricts immigration enforcement in places like schools, hospitals, and churches without a warrant. The U.S. Attorney General's office says this legal action is being brought as a result of New Mexico's sanctuary city status. Now it's up to a federal judge.
The Immigrant Safety Act is now.
New Mexico's Immigrant Safety Act, along with an Albuquerque city ordinance, are now at the center of a major federal showdown. In a fiery new lawsuit, Acting Attorney General Todd Blanche argues both are unconstitutional, saying they directly interfere with federal immigration enforcement.
This is going to wind up in court. It's going to wind up in the U.S. Supreme Court because there are a lot of other blue states that are attempting the same thing.
In more than 200 pages filed Friday, the federal government is asking a judge to declare HB 9 and Albuquerque's Safer Community Places Ordinance unconstitutional, invalid, and unenforceable. The DOJ wants both laws stopped, also asking for money towards its lawsuit's costs and fees.
It's not unusual for the federal government to file suit if they believe that a state is acting in ways that violate various laws.
The suit specifically refers to the Supremacy Clause, which says that federal law is the supreme law of the land. State law may not stand as an obstacle to the enforcement of federal law, the lawsuit states.
This is the federal government saying we have the right and the constitutional right to regulate immigration policy, and states, you don't have that right.
This year, the Immigrant Safety Act was celebrated by New Mexico Democrats as one of the biggest wins of the legislative session. It was signed into law in February and is set to take effect on May 20th. It bans counties from making deals with the federal government to detain immigrants for civil immigration violations. It also ends an existing contract with the Otero County Processing Center in southern New Mexico. Albuquerque's Safe City policy goes even further, requiring businesses to alert all workers within 24 hours if ICE agents show up at their job site, among other rules.
It's a really interesting legal issue, definitely going to wind up in the highest court of the land at some point.
The DOJ is now pushing for a hearing within the next 10 days. The case is currently in federal district court, but if it moves up, it would head to the 10th Circuit Court of Appeals after. Reporting, I'm Leah Chavez, KOAT Action 7 News.
The U.S. DOJ has not responded, but Mayor Keller writing, I will always stand up for the safety, rights, and dignity of Albuquerque residents. Our policies ensure all families can call 911, send their kids to school, and access city services without fear, while making it clear city resources are not tools for federal immigration raids. We're ready to defend our community, our values, and our public safety in courts.
Attorney General Raul Torres saying his office will defend HB 9, adding the Constitution reserves to the states the power to govern their own affairs, including how state and local personnel are deployed and how publicly funded facilities are used. Federal agents remain free to enforce federal immigration law. They may make arrests, conduct investigations, and carry out removals. What they may not do is compel New Mexico's officers, employees, and institutions to administer federal enforcement priorities the state has chosen not to adopt. And this fight is also shining a new spotlight on the Otero County Processing Center in southern New Mexico. The government calls the facility critical. It can hold nearly 1,100 people and is one of the few facilities equipped to house women and higher risk detainees. If HB 9 takes effect, the government says it will be forced in to quickly relocate everyone currently held there. And it's warning many could be moved 27 miles away to Camp East, Montana, and El Paso.